Welcome to U.S. Immigration TV. In this video, I will discuss whether Trump can end birthright citizenship for your children born in the U.S. Well, on his first day in office, Trump signed dozens of executive orders, including one entitled Protecting the Meaning and Value of American Citizenship, where he effectively attempts to reinterpret the U.S. Constitution and deny citizenship to certain children born in the U.S., which is referred to as birthright citizenship. Well, what is birthright citizenship? Who could be affected by this executive order? Is it retroactive? And I know there are many parents right now in the U.S. waiting for their U.S.-born children to turn 21 to enable those children to petition them. So will this executive order affect the children and those parents? And is what Trump is attempting to do legal or constitutional? What are his chances of succeeding? Well, watch this video until the end for the answers. And don't forget, of course, to like, share, and subscribe to this channel for more useful information. A little bit of background. The concept of birthright citizenship comes from the Citizenship Clause of the 14th Amendment to the U.S. Constitution, which states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Well, the issue of birthright citizenship is the meaning of that phrase, subject to the jurisdiction thereof, in the Constitution. And Trump's attempts to rely on that phrase to deny citizenship to certain people born in the U.S. Now, traditionally and historically, that phrase, subject to the jurisdiction thereof, was interpreted to exclude the children of diplomats from U.S. citizenship. After all, diplomats have diplomatic immunity, and they are not typically subject to U.S. jurisdiction. But now, Trump appears to want to extend that phrase by ending birthright citizenship to children, and here's the key to it, to children born of mothers who are unlawfully present or are on temporary non-immigrant visas, and the father is not a U.S. citizen or lawful permanent resident. So let me break that down. In other words, Trump believes that children who are born in the U.S. are not subject to the jurisdiction thereof and therefore not eligible for U.S. citizenship if, number one, the person's mother was unlawfully present in the U.S., such as being out of status, or the mother entered the U.S. without a visa, snuck across the border, and the father was not a United States citizen or lawful permanent resident green card holder at the time of the child's birth. Or number two, second concept where a person is not subject to the jurisdiction of the U.S. is when the person's mother was in the U.S. and in lawful but temporary status, such as the mother was on a temporary non-immigrant visa, such as a student visa, a working visa like H-1, etc., and the father was not a U.S. citizen or lawful permanent resident at the time of the child's birth. So if a person born in the U.S. fits into one of these two categories, then no governmental agency shall issue documents recognizing their U.S. citizenship according to that executive order. So this would effectively mean or include the State Department now refusing to issue U.S. passports to these American-born children. About retroactivity, that's a big concern for many of you out there. Will it apply to your children, or would it apply to, I guess, people decades ago? No, the executive order, according to its terms, will apply, and I quote, only to persons who are born within the United States after 30 days from the date of this order. So, meaning it's not going to be retroactive. So it means people already born in the U.S. will still be considered to be U.S. citizens. Good for all of you who are waiting for your kids to turn 21 to petition you. It's just that under this executive order, children now, in the future, after 30 days, born to mothers who are unlawfully present or who are on temporary non-immigrant visas will no longer be considered U.S. citizens unless the father is a U.S. citizen or green card holder. But what will the status of that child be if you have a case where the mother is out of status? Would the child also be out of status and therefore deportable, even though born in the U.S.? Well, the question now is whether this executive order is legal or constitutional. In my opinion, it is not. First, how will this executive order be enforced or carried out? When a mother gives birth, she's going to have to declare her immigration status at the hospital? Well, the father is also going to be needed to be identified and his immigration status be checked out to make sure he is a U.S. citizen or lawful permanent resident. I'm thinking that the government may also require DNA testing of the father to make sure that the person identified as the father truly is the father, in case the mother asks a U.S. citizen or lawful permanent resident friend to pretend to be the father and list him on the birth certificate where the actual father may be tago na tago or out of status. Second, it looks like Trump is attempting to extend, interpret, or even amend the Constitution by executive order. But in our government, it is the job of the U.S. Supreme Court to interpret the Constitution, including what the phrase "and subject to the jurisdiction thereof" actually means. And the U.S. Supreme Court has already done that. In 1898, the U.S. Supreme Court had already decided the issue of birthright citizenship in the case U.S. versus Wong Kim Ark, Chinese case, in which the court held that a child born in the United States of parents of Chinese descent, it doesn't have to be Chinese, it could be Filipino descent, but the parents were foreigners, who at the time of the child's birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, automatically became a U.S. citizen at birth. So this case established an important precedent in interpreting the citizenship clause of the 14th Amendment of the U.S. Constitution. And what I also don't understand is Trump was really getting angry, if you remember during his campaign, of what he called activist judges, judges who were going out and making new laws. He liked traditionalists, and that's when he was appointing Supreme Court nominees. He was saying that these nominees are conservative. They will stick to the letter of the Constitution and not attempt to legislate. But what is Trump himself doing with this executive order? He's being an activist president and interpreting the Constitution, reading things into it that are not actually there. Therefore, the issue or interpretation of this phrase, "and subject to the jurisdiction thereof," was already decided over 125 years ago. So I don't quite understand how or why Trump can now issue an executive order effectively overruling the U.S. Supreme Court. Now, I fully expect that lawsuits will soon be filed challenging this executive order. It's probably going to be by a mother who is in the U.S. on a non-immigrant visa and gives birth in the U.S., as opposed to like an out-of-status mother. Ultimately, that case will probably wind its way up to the U.S. Supreme Court, and they already have a precedent decision on this issue, interpreting that clause and holding that a child born in the U.S. to non-citizen parents is a U.S. citizen at birth. I will continue following this executive order and its status, as well as the dozens of other executive orders signed by Trump, all affecting immigration. We're in for a roller coaster ride, believe me, with Trump, because he promised just to have a complete upheaval and revamping of our immigration enforcement. So please make sure to continue to watch this channel and, of course, like, share, and subscribe. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.